ask you to please wait for now. Let's listen to Professor Auwal Yadudu, who is already here with us. He's a very familiar name. I'm not sure he needs introduction, but if I must introduce him, Professor Yadudu served as Dean of the Faculty of Law, Bayero University in 2016, became Vice Chancellor of the Federal University, Benin, Kebbi State. Professor Yadudu served as the legal advisor to the late head of state, General Sani Abacha. He also served as the Deputy Chairman of National Conference Standing Committee on Law, Judiciary, and Human Rights. So, ladies and gentlemen in the House, let's give the floor to Professor Auwal Yadudu.
Well, thank you for the opportunity, and as I had allotted you, I have a very short leash. I fasted today. I just had to join because I gave my words that I will join you. Now, I've listened to the elucidation of the gentleman who has just spoken, and I don't know where to start, actually. First of all, I think in your introduction, you mentioned that I was appointed Vice Chancellor Benin Kebbi. Well, I was appointed, but I didn't take up the appointment, and the mistake keeps being repeated. I'm not a Vice Chancellor of any university. And I was Dean over 30 years ago in Bayero University, where I am at the moment. Now, let me just speak in snippets, so to speak. First of all, I think if I may take an issue or two from the presentation just been made. One, I think we do not, we do have in our constitutional system, in our legal system, a recognition for religious laws, and this does not start or end with Islamic law. Bigamy is a crime, even if not enforced, and it's in our statute book. There are other crimes which have derived their origin from Christianity, as some have also derived their origin from Islam, and also some from customary practices. This is one thing I would like to say. Secondly, I don't know what to make of the position that the gentleman has taken on Section 10, whether it recognizes Nigeria as a secular state or multi-religious or something else. I think it says what it says. Neither the state nor the federal government shall adopt a religion as a state religion. And it's so nebulous. Unfortunately, it has not received the necessary judicial scrutiny and interpretation to give us an idea as to what the framers actually meant when they couched the section the way they couched it. There was a feeble attempt in '79 to challenge the section in Lagos by the Catholic Church. It didn't go far. And I was amazed to hear Mr. Sam said that they took the issue up in Zamfara, up to Court of Appeal. I'm not aware about what suit that is and what the decision was. If it has gone up to Court of Appeal, I would imagine there was a ruling one way or another at the lower court, and I would be interested to know what the issues were and what the decision of the lower court had been. Now, the third thing I'd like to raise is regarding so really, the issue is that you have a constitutional provision couched in the language it has been couched to take into account whatever those who designed it thought was on the ground. But of course, as I said, it has not been subjected to judicial scrutiny to come to a decision one way or another. The third point I wanted to make, again, because I listened to his presentation, was that he would not subscribe to too frequent an amendment to the Constitution because it's only where politics are unstable that you have too many changes. You'll be surprised. I'm sure he should know that the U.S. Constitution suffered so very many amendments at its takeoff, which have been numbered, and I think the last count is I think number 22. And of course, so it may be that a system at that stage was also unstable, but they went through the necessary amendments to plug things and to flesh things up and to give direction in the manner that they wanted. So I don't think it is fear of running away from political instability that will encourage one not to subject to the Constitution for an amendment or some adjustment here or there. Now, let me just say 2 or 3 things just by way of my own independent observations, apart from what I have said about the presentation made. The mistake and has been continuously made that this constitution, the 1999 Constitution, is a military imposition, and we should have nothing to do with it. And we are doomed to failure if we do not throw it into the ditch. My take on the 1999 Constitution is that really it is a constitution that has only updated the 1979 Constitution. You might say that also the 1979 Constitution itself was an imposition of the military. But I think the basic structure of the 1999 Constitution is a continuation of the 1954, 1960, 1963 Constitution, which is that you have a chapter on judiciary, which essentially has remained what it is. You have a chapter on fundamental rights, which, as far as I can tell, also has only been improved upon. You have chapters that define and prescribe the powers of state, of the executive, the judiciary, the legislature, only that this is an executive system and not a parliamentary system. And so if you look, and of course, again, you have a constitution that has distribution, legislative list that is distributed between the exclusive and the concurrent. What in these features is uniquely an imposition of either 79 or of 99? It is a continuation of what we have gone through. It is not a perfect document. It can be vastly improved. There is much in it that can be tweaked, even overthrown. But I think it is a fallacy to keep saying that this is an imposition and that we would go no further if we do not jettison it. Associated to this point is the silly case that is being made that this constitution is authored by my humble self. Well, I will accept the notoriety. I will accept also the honor, if you consider an honor, that I authored the Constitution. But of course, the 1979 Constitution came about as a result of a deliberative process, which was chaired by late Justice Niki Toby, and a report produced, and the military adopted and promulgated a constitution which has the features I had just described. The final point I'd like to make I think by reference to restructuring is that since there are so many checks on what people mean by restructuring, and if you want to discuss it in relation to the Constitution, stop beating about the bush. The existing legal order is the 1999 Constitution. It has ways and means and provision for changing it, including even entirely overturning it. Now, whether we are able to develop enough political consensus and will or power to do so is another thing. So to me, I don't see any problem about restructuring. Whether you want to combine the whole of Southwest to become a region again, or whether you want to combine the 6 zones to become the political entities making up the federation, or what if you want to do a confederal system, whatever it is you want to do, I think you can only work within the existing legal order, and you have no other basis for changing things except in accordance with the existing legal order. Now, of course, I know the answer to that is that, of course, it is difficult to achieve and what have you. But you see, wherever you go, when constitutions are changed, when societies change, they make the most of what they have. And of course, you can change it by a revolution if you can afford it. Obviously, you can throw it out and you can enthrone whatever beautiful ideas you would want to enthrone, by not necessarily by reference to the constitutional provision. So my take really is on those issues for now. Thank you very much.
Thank you very much, sir. Thank you for that wonderful insight.